a little after 10 o'clock. When we're going to call the roll, and when you do, please indicate not only your presence but where you are physically located. Donita, will you call the roll, please?
Sure. Christopher Lilly,
Present in person.
Dave Nicholas,
Present right here in the capital city.
Mike Scholl,
Present here in the Capitol.
Marie Rader, she's absent today. Tanya Pullen,
Here, and I'm in Greenup County.
Gail Russell,
Here, and I'm in the annex.
Sal Santoro,
Here in the annex.
Arnold Simpson.
Here in Covington.
We have a quorum.
We have a quorum, so duly constituted to do business. The first order of business is the approval of the minutes of the July 8th, 2025 meeting. Is there a motion for approval?
So moved.
Second.
Motion made and seconded. All those who in favor signify by saying aye.
Aye.
All opposed, no. The ayes have it and is so ordered. We're going to defer the staff report to later in the agenda. The first order of business we're going to take up is a pending motion to dismiss and response, which have been submitted for the consideration of the commission. And we'll do that in open session, and then we will deliberate in closed session. I'm going to appoint my Vice Chair, Mike Scholl, to be the hearing officer for this part of this meeting, and so I'll turn it over to him.
Thank you, Mr. Chair. So this is the consolidated case of case numbers 24 LEC 03 and 24 LEC 06. We have what has been submitted as a motion to dismiss, submitted to the council or to the commission, and a response also filed. As Chairman Nicholas said, we'll deliberate on the motion in closed session. We don't have to have argument in open session. Mindful that it is in open session. Ms. Whites, I'll start with you if you're here on behalf of Representative Grossberg. But do you wish to make an argument, even though it's in the open session? I want to
Yes,
make sure
we do.
you're aware of. Okay.
Yes, absolutely.
Okay. Proceed.
Thank you. I appreciate the body allowing us to speak briefly on this motion. It is Representative Grossberg's position, not for dilatory purposes, that this matter should be dismissed on several grounds. The first, which the body will be addressing today in the pending motion to dismiss, is because through no fault of the body, the government contract was not applied for in the manner required by statute or regulation. Mr. Jenkins was hired without a contract that is approved by the legislature, government contract review, and that contract, to the best of my understanding, is still not approved. There has been some discussion in the response that this was payment only, that it had nothing to do with employment. I do not read the regulations or statutes as limiting the approval to just whether or not you pay someone who is working for you and on your behalf. There is a big concern that because this matter in the early stages during discussions and during the preliminary hearing was confidential by order of the body and by statute, that Mr. Jenkins, as a private individual and not an appropriately employed or contracted attorney, was present through that, was acting in a legal capacity, and had no valid contract. That puts not just Representative Grossberg, but any witness, any testimony, any evidence that was otherwise privileged at risk because he was not a contracted employee. For this reason, we would say the motion to dismiss should be granted and that matter should be dismissed because it was not handled by an attorney for the board as it is supposed to be. It's particularly challenging when the board is acting as judge, jury, and prosecutor through itself and its contracted employees, and outsourcing that to somebody who is not contracted or employed validly under state law is of significant concern. We note that there was a suggestion from the government review, that there be an appeal, that there be discussion within a certain number of days. I have represented state agencies who have made the similar error and have had to go through the appeal process. It is my understanding that this body chose not to, that they just moved ahead, continuing to treat a non-contracted individual as their employee and attorney in this matter. So for those reasons, we'd ask for dismissal of the case. We also filed today a renewed motion to dismiss. We deposed two of the primary complainants, Representative Stevenson and Representative Roberts, last week. We don't have the transcripts yet, so there will be a fuller motion to dismiss. During that motion to dismiss, both complainants said they had no knowledge at all of what they put in their complaints, that they based it on anonymous assertions, on rumor, on gossip, maybe on a newspaper article in some cases. The board's complaint procedures require under oath a complainant to state, I know this as a fact. Here is when it happened. Here are the approximate dates. So there was a clear intent to just throw, as one of them said, the kitchen sink into the complaint and rely on this body to sift through and find out if there was any merit to any of it. They also discussed a culture of political misconduct, of drinking in the Capitol during work hours, of taking THC-laced gummies at work. One of the witnesses said the LRC has no policy prohibiting drinking or that type of behavior while at work. Having worked with hundreds of legislators and dozens of leadership on the Democratic side, but knowing what the other side does as well, I know that's not true. That is wildly inappropriate, and Representative Grossberg brought those complaints to the attention of that minority leadership, who are no longer legislators, before they filed the complaint against him, showing not just abusive process, because they had no knowledge of anything they put in their complaint, but political misconduct and shocking bad behavior and retaliation against him for reporting that. I asked about policies. Do you have policies that you use for people to report complaints that govern compliance? And the response was, this is not a government or business entity that has that sort of policy. Again, certainly not my experience, and I'm sure not yours. And so we will be filing that renewed motion to dismiss for abusive process, and also asking that this body, to the extent it can, with somebody no longer in office, look at that misconduct, which shockingly included accepting political contributions for their private campaigns on Capitol grounds, in their offices, from PACs, lobbyists, and others, and in fact handing those out to other lobbyists, or in the case of Representative Grossberg, leaving one on his desk for him to find, which we appropriately at the time returned to the PAC who had provided it, explained the problem, and he filed a complaint with them against that, or didn't file a complaint. They had no process, but registered a complaint. So I think as we look deeper and finally publicly into this case, we will find top to bottom that it was a political hit job, that there was no merit to it, and that the complainants mismanaged their office in a way that is shocking and appalling and should completely invalidate any allegations they made under oath. They were also under oath in their depositions. So we will be asking for a hearing date on the renewed motion and a briefing schedule if the body wants to give us a page limit or a time limit on that.
Okay. Have you actually filed that motion? Or you're
This
saying
morning,
you're
yes,
going
sir.
to file the motion?
Yes.
Okay. Well, having not been able to review it.
No, sir. I just did it this morning. I was holding out, hoping for the transcripts, and I have not received those.
Okay. Mr. Jenkins as enforcement counsel.
As for the, as for the renewed motion to dismiss, I was just handed this when I walked in this morning, and obviously I would like an opportunity to respond.
Totally understand.
I'm not going to address what was just said, and I think to a large extent mischaracterized, and some misstatements made about what the actual transcript will be. I'll wait and include that, and we may need to as far as a briefing schedule goes, we may need to get back with you after we get the transcripts to let you
Yes.
know when we have the transcripts, so we can, in other words, if we just say 30 days from today and we don't have, for more briefing, if we don't have the transcripts, then we wouldn't be able to file something, so.
Yeah, I think we can probably
And we've asked the
schedule a
court
status
reporter to
conference
be-
to talk about this once we see the motion
Right.
and set a response date, et cetera.
As far as the pending motion to dismiss, prior to the preliminary hearing, I was informed of the government contracts actions, and I stated that in my response. And I mentioned that to staff, and I mentioned that, who I believe discussed that with the chair or others on the commission, and I was told to proceed. Certainly, in the eyes of the commission, I was the enforcement counsel on that day, authorized to proceed. The cases cited in the motion are not appropriate and or not on point. And in fact, the Lexington Public Library case, I think, is actually states the opposite. Lovell versus Winchester also mentions, which I cited in my brief, that the lawyer-client relationship can arise not only by contract, but also from the conduct of the parties. And the conduct of the parties here absolutely authorized me to proceed as I did, and have allowed me to proceed since the hearing. And the issue of whether I was authorized, quite frankly, in my mind, is a matter for the commission, and for the commission to decide if you felt that I was authorized. That is, I have briefed it, but I think in the eyes of the client, ultimately it is up to, for the attorney-client relationship here, I think it is up to the commission. I believe the commission's actions were evident and have continued to be, and I think that the model procurement code, as it relates to the contracts, actually directs the government, directs the disapproved contracts be forwarded to the finance cabinet. Well, the finance cabinet doesn't have anything to do with legislative contracts. And LRC did authorize, indicate its intent, or I'm sorry, the commission did indicate its intent for that contract to go forward, and forwarded that, I believe, to the director's office. I'm not certain of all of the other actions taken by the commission or commission staff, and commission staff can discuss that with you. But in my eyes, I was authorized to proceed. I've done so, and I certainly have no intention to divulge any confidences or break any privileges that exist. And I would ask that the motion be denied.
May I have 1 minute for rebuttal?
You can have 1 minute, as long as I gave you a little bit of leeway there, Ms. Whites. You're kind of arguing your motion that you just filed this morning that
Yes.
we're not debating about
No,
today.
rebuttal
So
on
let's
the
keep it to the,
pending motion. Yes, sir.
and Mr. Jenkins, if you need a sir rebuttal, I will grant that to you as well.
Ever increasing time. Our rebuttal would be to remind the commission that Mr. Jenkins' contract was not affirmed to the extent it was by them until after the preliminary hearing. It may have been the same day, but it was after the hearing had closed. And we would argue that the conduct of the parties is not relevant to use of taxpayer funds. It really may not matter to the voters what you all wanted to do. Adherence to the government contract statutes and regulations is vital, and absolutely no imputing Mr. Jenkins on this. I don't think he's out on a street corner breaching, but the principle remains the same. People are at risk when unauthorized parties are privy to these meetings, as we've discussed at length in the meetings on both sides.
Ms. White, is there a date through which you stipulate that Mr. Jenkins was acting inarguably on behalf of the commission?
I would have to pull those contracts, sir, and I don't have them in front of me, but I know there was a period of several months when he was not, and that includes the preliminary hearing and preparations therefore.
So you're arguing that Mr. Jenkins was not acting as enforcement counsel for the commission for the last several months, not just one meeting?
Correct.
'Cause I misunderstand that, I guess.
No, that is our argument, and I'm not saying he was not acting as counsel for you. I believe he was acting as counsel. I believe he was not legally authorized to act as counsel.
Okay. Mr. Jenkins, do you have anything else? Okay. Is there a motion to, pursuant to KRS 61.810 1C, J, and K, motion that the commission go into executive session to discuss and deliberate the pending motion as well as any confidential complaints?
So moved.
Second.
All in favor?
Aye.
Opposed? Okay. I'll turn it back over to you, Mr.
Okay. We'll be discussing the matter in closed session. And when we're off the air and everyone's out of the room.